Morning. I'm Dr. Howard Kraus, Chair of Panel B. My agenda items indicate a 9 a.m. start. Some other people have seen some materials that indicated the 9:15
Mine said
start.
9:15. I got one that said 9 and one that said 9:15 after that.
If
Me
all,
too.
I'm ready.
if all assembled are prepared, we may start at this time. I'd like to introduce Administrative Law Judge Jill Schlichtman.
Good morning, everyone. All right.
Actually, I should have asked for a roll call first. I'm sorry.
Dr. Kraus,
Present?
Dr. Bolat,
Present.
Dr. Nanadev,
Here.
Ms. Lawson,
Here.
Dr. Levine, Ms. Pines, Ms. Sutton-Wells.
Here.
We have a quorum.
Thank you. Judge Schlichtman?
All right, thank you. Good morning, everyone. Let's go on the record before the Medical Board of California in the matter of the accusation against Elsika Sagi Shaham, MD. This is Office of Administrative Hearings, case number 2015-07-0757, and board case number 17-2013-235259. Today's date is July 28, 2016, and we are here in South San Francisco for the hearing on the non-adoption of the proposed decision in this matter. I will take the appearances of counsel at this time, starting with Complainant's Counsel.
Good morning, Cindy M. Lopez, Deputy Attorney General for Complainant.
Good morning. Albert Garcia appearing for the respondent, Dr. Shaham, who is present.
Good morning.
Good morning.
All right, I'd like to remind everyone that the purpose of this hearing is simply to argue the evidence that is already in the record rather than adding new evidence. And I'd also like to remind the parties that the respondent will begin with 15 minutes. We'll keep a close eye on the stopwatch, so please don't go over your time limit or I'll have to interrupt you. And then followed by Complainant's Counsel for 15 minutes, and each side then getting closing argument for 5 minutes. And Mr. Garcia, I understand that Dr. Shaham has chosen not to address the panel directly. You'll be handling the argument.
I will, Your Honor. Thank you.
Okay, perfect. All right, then I will invite you, Mr. Garcia, to address the panel at this time.
Thank you. Just a question here. Is this a timer here in front of me, or are you going to give me the time?
I can.
It doesn't matter. Just says 3 minutes right now. So. It doesn't matter. You could just signal me. It's okay.
Okay, would you like me to let you know when you have a couple minutes left?
I'd appreciate that.
All
Thank
right,
you.
I'll hold up my hand. Okay, go ahead.
Thank you very much. Good morning. I want to start by referring to a very, very recent case that I think is very important for the issues that we have to determine here today. And the case, which was decided in the late June and just certified for publication on July 11th. So, Your Honor, there is no reporter's citation to it, but I will give you the name of the case and the docket number. The case, and I'm sure that the board is aware of it, is Amir, A-M-I-R, Peruzian, P-I-R-O-U-Z-I-A-N, Second Appellate District, Court of Appeal, California, docket number B as in boy 266015. And the reason I want to refer to that case is that, pardon me, it involves a writ of mandate that was issued by the Court of Appeal, setting aside a revocation that had been ordered by this board. And
I'm sorry, Your Honor, I don't mean to be rude and interrupt, but I haven't seen this decision, and obviously it's going outside the record, so I'm not sure if the panel needs to hear about this.
Well, it's not new evidence, it's just legal argument, so I'm going to allow that.
thank you very much, Your Honor. And the decision reminds us, of course, that what the purpose of discipline is. And it reminds us of the adage that punishment is not the goal. And it indicates here that although the board has discretion in determining the discipline to impose for unprofessional conduct, such discretion is not whimsical, uncontrolled power, but a legal discretion which is subject to the limitations of legal principles. Now, I'm going to refer to three factors that the court looked at in setting aside that decision because those three factors are squarely applicable to the facts that we have in this case, and I'll get to those in just a moment. But in setting aside the discipline in the Perusian case, the court first noted that the misconduct there had occurred over a discrete period of time. Second, it took note that other than the misconduct involved in that case, the respondent there of the Dr. Perusian had an otherwise unblemished professional record with no disciplinary history. And finally, the court indicated there was nothing in the record to indicate that Dr. Perusian would ever reoffend. So the Court of Appeal there focused on the purpose of discipline, saying what is necessary when you impose discipline, what you're looking at is what is necessary to protect the public health, safety, and welfare. In this case, the administrative law judge who heard the evidence over the course of a 3-day hearing and was able to assess that evidence firsthand, of course, made a determination that a public letter of reprimand would be appropriate to protect the public health, safety, and welfare, and that probation was not necessary. That probation would not be necessary to protect the public interest. That was a determination made by the ALJ after hearing and assessing all the evidence. Now, what was that based on? Obviously, we have a rather long proposed decision with many factual findings, but I'm going to refer you to what I believe is the linchpin factual finding upon which the proposed disciplinary order was based. And I refer you to factual finding number 32. And here, the administrative law judge, incidentally, that was Judge Dash, indicates respondent has practiced for more than 30 years. That's in the record. And up until 2012, he was a board-certified OBGYN. That was his practice. And then he went into semi-retirement in 2012 and ventured into this area of recommending marijuana for medical purposes. And by the way, the accusation in this case and the decision is based on two recommendations made in the year 2014 to two undercover officers. But anyway, factual finding 32. Respondent has gone back to the practice of obstetrics and gynecology, but whereas he used to deliver 50 to 70 babies per month, he now delivers less than 10 babies per month. He goes on to say, and this is really crucial to his determination that a public letter of reprimand was appropriate to protect the public interest. The ALJ says, official notice is taken that the care and treatment of pregnant women and the delivery of babies requires a high degree of patient management and skill, the utmost diligence in performing physical examinations, and the preparation and retention of extensive medical records. After more than 32 years in practice, respondent has no history of board discipline. And by the way, the record also indicates that Dr. Shaham still maintains privileges at Hollywood Presbyterian Hospital and Good Samaritan in Los Angeles. So, going back to the Perusian case and the factors that were looked at there, a discrete period of time, the misconduct occurred over a discrete period of time. After 30 some odd years of practice, Dr. Shaham goes into recommending medical marijuana on a part-time basis in semi-retirement. He makes two recommendations over a period of 2 months. That's it. You look at his overall professional career spanning 33 years, and you see two incidents occurring 2 years ago, a discrete period of time. Number two, an otherwise unblemished professional history. And again, remember what Judge Dash is saying here when he's taking official notice. He's saying, look, this doctor has practiced for 32 years in a very exacting, a very demanding area of practice, OBGYN, which requires, as he indicated, a high degree of patient management and skill, the utmost diligence in performing physical examinations, and the preparation of medical records. Now, those are important because those are issues that came up in this case. In this case, it's alleged that the marijuana recommendation was issued without having conducted an appropriate physical examination and that the documentation was subpar. So Judge Dash is saying, look, this man has practiced in a much more demanding area. He knows how to conduct physical examinations. He knows how to maintain records and obtain histories. It's not he doesn't know it. He knows it, because otherwise he would have gotten himself in trouble a long time ago. And he didn't. 32 years, unblemished history. And also, there's nothing in this record, as in the Perusian case, to indicate that Dr. Shahan will ever reoffend, because, as Judge Dash notes, he went back to practicing OBGYN. That's what you're looking at. Now, obviously, this board decided against adopting that proposed decision. And I mention here that in doing so, I think that the old adage that we hear all the time that discipline is not to impose, it's not for purposes of punishment, I think it's put to the test here. Why else would you impose more discipline on this particular doctor? You have a very experienced, competent doctor. And the two incidents that occurred here in that very discrete period of time were obviously and clearly aberrations. That's the way Judge Dash looked at them. So what probationary conditions would you impose on this particular doctor to protect the public interest and make him a better doctor? Now, I kind of made a tongue-in-cheek remark there in my written argument, and I indicated, look, it's not like Dr. Shahan woke up one morning in 2012, that's when he started recommending marijuana. He woke up suddenly forgetting how to conduct physical examinations and how to obtain medical histories and how to document them. That couldn't have been the case. So what kind of conditions would you impose on this doctor to protect the public interest and make him a better doctor? I can think of none, and ALJ, Judge Dash, could discern none, and that's why he indicated that probation was not warranted. Now, how much time do I have, Your Honor, by the way?
You have another 5 minutes.
Okay, well, I'm going to be very brief, obviously, I have no choice, and indicate that because the order for non-adoption indicates that the board would look at the entire case, I do think that I would like to spend a little time just indicating that there's some issues in this case that I think should be taken note of. And one of them has to do with the legal issue of whether marijuana could be recommended to patients who do not suffer from serious illnesses. Now, I briefed that extensively in the written argument, and my expectation is that you read and looked at it and considered it. It's a very important issue because the expert in this case said, look, you can't even recommend marijuana for anyone unless that person is seriously ill and suffers from these serious medical conditions. And as I indicated in the written argument, the term seriously ill has been read out of the Compassionate Use Act by the courts of the state. And I know the argument is, well, those were criminal cases. I understand that argument. But there's nothing in those decisions, in those holdings, that make that interpretation specific to criminal law. It's just that the courts were looking at that language and were saying to themselves, is this part of the act, or is this a prefatory statement, a preludial statement, an introductory statement, if you will, which does not really fit into the substantive part of the statute and therefore does not limit the protection of the act to seriously ill Californians. So that's a legal issue that I think is very, very important, and it might go up on judicial review depending on what the outcome of this hearing is. And the other thing is, I think there were some serious credibility issues with the two undercover agents. You must remember that the whole case here has to do with what those undercover agents said occurred during their consultation with Dr. Shaham. It's a he kind of situation. You know, he said. And so their credibility becomes important. And one of those officers testified that when he went for his undercover visit, he saw juveniles in the office. Now that's important because this whole case started with an anonymous complaint indicating that Dr. Shaham was recommending marijuana to the kids in the valley, San Fernando Valley. Kids in the valley. That's what started this investigation. So he goes in there and he testifies under oath that he saw juveniles during his undercover visit. But in a declaration that he prepared immediately after his visit, he says nothing about it. In the investigation report that was prepared in this case, all part of the record here, there's no mention of any juveniles being in that office. So how, as I sit here and as you sit there, if you have an investigator who goes in based on a complaint that kids are receiving recommendations, and he observes them in that waiting room, wouldn't you think that that would be something he'd document in his declaration and would be included in the investigation report? It was not. And yet he got up on the witness stand and testified under oath that he saw juveniles in there. That's incredible testimony. And under the law, thank you, under the law of evidence, if a person testifies falsely as to part of his testimony, the trier of fact, and this is the tribunal here, the ultimate decision maker in the case, can disregard his entire testimony. And there were other problems with the other investigator as well, not as blatant as the one I just mentioned, but that one is clearly blatant because if you go in there based on an anonymous tip that there are kids getting recommendations, you would think that if you actually saw the kids there that you'd make that a big point in the case and put that in your declaration, put that in your investigation report, and as this board can see, there wasn't even an allegation in the accusation that juveniles were getting these recommendations. So that didn't bear out. It didn't pan out at all. And for him to get on the witness stand and say otherwise, I think speaks volumes about the lack of his credibility. And this case has to do with what he said occurred in the privacy of his consultation with Dr. Shaham. Your Honor, I'm going to reserve the last minute or so for my rebuttal. Thank you very much.
Okay, thank you very much. All right.
No, I think we should proceed.
All right, Ms. Lopez, your argument?
Good morning. As the panel knows, the issue in this case really comes down to the discipline, but I do want to respond to several of the arguments that respondent made in his brief. And without being disrespectful, I feel like I was at a completely different hearing and read a completely different proposed decision based on his brief. So he starts out with Judge Dash, the ALJ, and he says that Judge Dash saw and understood the aberrant nature of the claimed deficiencies, and he saw no public interest in proposing probation. He points out that an agency may not disregard an ALJ's credibility findings unless there's substantial evidence of the reliability of that testimony, and he goes on to say the ALJ did not get it wrong. He makes an even more interesting point when he states that the ALJs must be members of the medical quality hearing panel because they have more training, they're more experienced. So, as an experienced member of the panel, you must accord great deference to Judge Dash's findings. I totally agree. What's interesting is respondent fails to point out that every finding went against him except the very, very last paragraph. Judge Dash did not find respondent's expert credible. He did not believe respondent when he testified that he performed physical exams. He found him to be dishonest. He found his record keeping to be inaccurate. Those are the credibility findings that I agree this panel must give great deference to. Now let's talk about the standard of care because I agree with Mr. Garcia, it's very important in this case. The standard of care, and this is at page 7 in the proposed decision, it talks about the Compassionate Use Act. The term seriously ill, as used in the statute, is not specifically defined, except by example. These examples evince a legislative intent that medical marijuana is to be recommended not for any condition for which it might provide some relief, but rather for conditions that cause substantial pain, disability, impairment, handicap, and the like. The expression, quote, any other illness for which marijuana provides relief, unquote, means, quote, serious illness, unquote, by the use of that term earlier in the same subdivision, and is evidenced by a list of examples of medical conditions. Now, I realize that this is getting in the weeds of legal analysis, but what he's saying is that there has to be a serious condition, not just something that marijuana can provide relief for, which is what respondent has argued. Now, in his brief, respondent is just plain wrong. Now, I find it interesting that he finds Judge Dash correct on his finding that a PLR is appropriate, but never once in his brief does he mention that Judge Dash believed complainant's expert regarding the interpretation of the standard of care. Respondent argued at hearing and now in his brief that the criminal law says that the term seriously ill is not prefatory. Is solely prefatory. It's not. And he cites to a case, and again, I don't want to get into the weeds, but it's talked about in footnote 7 at page 7. Again, on the legal analysis, respondent is just wrong. He argues and asks, what other evidence did we present on the issue of the standard of care regarding medical marijuana, other than our expert's opinion? Well, none, because an expert's opinion is all you need to substantiate findings. He argues that we failed to present clear and convincing evidence of the standard of proof. When he does his rebuttal, you might want to ask him what evidence he expected us to show. Now, he talks about the facts of the case and the investigation. He argues that Dr. Franklin, who is a complainant's expert, had no experience in recommending medical marijuana. The record belies this. He had 5 to 10% of his practice involves that. Respondent claims the manner in which this was investigated undermines the case. Judge Dash didn't seem to think so. He believed our investigators. He didn't find anything wrong with the investigation. Respondent takes issue with how long the investigation took. So, he takes issue with the fact we got an anonymous complaint. So, he takes issue with the fact that the investigators met at a parking lot after a debriefing. Again, this just turned off. And undercovers do that all the time. After an undercover, they go and debrief. He takes issue with what the investigators testified to. Judge Dash didn't, and he was the trier of fact. There's also this issue of monitoring, which was discussed ad nauseum at the hearing and in the briefs. He takes issue with one investigator saying he had a monitoring device, another one said he didn't, it didn't record. Then respondent and his counsel accused both myself and the investigators of withholding evidence. Again, the record belies this. And Judge Dash never mentioned it. So if we look at the decision, so again, I'm going by what respondent argues, having Judge Dash and this panel give great deferential treatment to his findings. Regarding investigator Boyd, Judge Dash found respondent did not conduct a medical or physical exam. Regarding investigator Buscarino, despite performing no physical exam, respondent recorded in his records that the thyroid was normal, the heart was regular. Giving deferential treatment to Judge Dash, he found respondent failed to take a medical history from either undercover. Judge Dash found our expert more credible, to the point where he basically copied word for word the expert's report into his proposed decision. I can tell you, after 22 years of doing these cases, I have never seen that. So if our expert was so not credible, why is every single word of his expert report in the proposed decision? Judge Dash found that respondent's expert recanted his testimony by acknowledging that many of the things that respondent failed to do were in fact required by the standard of care. So yes, let's give deference to the ALJ's findings. Now, respondent repeats over and over again, he's practiced for 33 years in a specialty which requires a high degree of patient management and skill, the utmost diligence in performing physical exams, and this is why he's arguing that Judge Dash did not put him on probation. Here's the problem with Judge Dash's recommendation. So as you're reading the whole decision, he does a fantastic analysis. He finds in favor of every finding in favor of the complainant, yet he issues a PLR but says that the respondent cannot issue medical marijuana recommendations. He can't do this. If you look at the disciplinary guidelines, for findings of gross negligence, which there were in this case, discipline is a minimum of 5 years probation. For findings of dishonest acts, in this case he found that, the minimum is 5 years probation plus suspension time. For findings of failure to keep accurate records, made in this case, the minimum is 5 years probation. For failure to perform a physical exam, again, findings in this case, it's 5 years plus suspension. Again, not to be sarcastic, did you hear me mention public letter of reprimand in that? No. So I would ask this panel, when you look at the guidelines, and then you look at this case, and you look at the findings, unfortunately, you can only issue a probationary order. Business and Professions Code section 2227 allows a PLR to issue with education courses. So in this case, the judge said he needs to take medical record keeping, no problem, but again, he adds the license restriction, and he's not allowed to do that. So in keeping with the theme of respondent's brief, I absolutely agree. You need to give great deference to Judge Dash's findings until you come to the very last paragraph. Now, regarding this case of, I think it's Perusian, I have not seen that case. I don't know what it's about. It sounds like a revocation was overturned, not really applicable to this case. This is not a revocation being overturned. So I'm at a little bit of a disadvantage, so I don't really want to say too much about that. But again, I would ask this panel to look at the order, to look at the disciplinary guidelines, and to rule accordingly. Thank you.
Thank you. Mr. Garcia, you have an additional 5 minutes, so you can start now.
Thank you. First of all, I want to start by saying that I have made no attacks at all on counsel. And every remark I made in my opening statement had to do with factual finding 32 and the Perusian case and the factors that are mentioned there. I have no attacks on counsel. And in fact, if you look at page 17 of my brief at footnote 57, when I'm referring to the withholding of evidence, I say the ensuing remarks concerning the prosecution of the case are intended to apply to the questionable conduct of the board's enforcement unit and the investigators involved in the case, and are not intended to apply to the office of the Attorney General. I make that very clear. So I think that that's an unwarranted kind of attribution that's been made here. Now let me go to the guidelines. What are guidelines? I remember a line from the Pirates of the Caribbean where one of the characters wants to parlay with the captain of this pirate ship, and she says, well, you know, these are rules. He says, no, they're not rules, they're just guidelines. Well, they're guidelines. And Judge Dash, who's been around for a long, long time, I indicated in a footnote, he's been in ALJ since 1988, he knows what he's authorized to propose as a disciplinary order or not. Guidelines are guidelines, and what he did in factual finding 32 is he told you why he was deviating from whatever guidelines might be otherwise applicable. He gave you the reasons for it. So this whole notion of you can't issue a PLR, I think it's incorrect. I think it's well-intentioned argument, but it's incorrect. The board has wide discretion to impose or fashion a disciplinary order that's appropriate for the particular facts and circumstances of the case before it. Now, in the Perusian case, the reason I mentioned that is because and the fact that it's a revocation has nothing to do with it. It's a disciplinary order that was set aside because the court there found that there was an abuse of discretion, and the abuse of discretion was based on the fact that the court looked at the fact that the misconduct occurred over a discrete period of time, as in this case. There was otherwise an unblemished professional career, as in this case, and no indication that that doctor would ever reoffend, as in this case. That's why I mentioned it, and I think, obviously, those factors are reasonable to apply in any case, and certainly in the particular facts of this case. So don't be misled by, well, it was a revocation, so it's not applicable. No, the principles involved are what we're looking at, the overall principles. Now, in terms of the legal issue of seriously ill, California, I briefed that at length, and the reason I put that in there is, and when I talk about was there any other evidence of the standard of practice, what I was referring to was this. The board's expert came in, and his whole opinion was based on this notion that you have to have a seriously ill patient threshold before you can issue a recommendation. And the argument it's a legal argument, by the way, a matter of legal interpretation, Your Honor. And so there, if the courts have said, no, that's not the case, that term, seriously ill, does not define, does not limit, does not in any way modify the actual terms of the statute, then he was wrong in making that opinion. That was my point, that he was wrong, and there was no other evidence of the standard of practice other than what he said, which I believe was wrong, based on the legal principles that I've cited and discussed in the brief. So, in terms of the factual findings that were made, yes, Judge Dash made these factual findings, but that's not enough. Look, there were factual findings in the Perusian case, dishonesty, and others. And the Court of Appeal did not say, well, we're setting aside those factual findings. That's what the Court of Appeal said. We're saying, we'll accept those factual findings, and notwithstanding that those factual findings were made, the penalty that was imposed was inappropriate. And that's what we're saying in this case. If you impose anything more than what Judge Dash has already recommended, based on his experience, based on his firsthand, in-person assessment of the evidence in this case, if you impose anything more than what he thought was required based on his experience and based on his hearing the evidence and assessing it, then it would be an inappropriate penalty because, as I mentioned before,
Mr. Garcia, your 5 minutes is up.
What about the 1 minute I reserved?
Well, if you can wrap it up very quickly.
Okay, that's it. Well, the whole notion is really not the factual findings. Yes, the factual findings are there. It's why the proposed disciplinary order was made, and you look at factual finding 32 to tell you why he deviated from those guidelines. And I think that a public letter of reprimand was the appropriate measure here. Thank you very much.
Thank you. All right, Ms. Lopez?
So I'll start where Mr. Garcia just left. Page 22, the proposed decision, paragraph 15. Judge Dash does not anywhere here mention why he's deviating from the disciplinary guidelines. And again, what Mr. Garcia and respondent failed to understand is this is a violation of the Business and Professions Code 2227, which says that a PLR may issue along with educational courses, but you can't have a practice restriction. Now, I want to make this very clear. I am not arguing that you should give him a PLR and medical record keeping. I want to make sure that that is clear. What I'm arguing is he needs a probationary order. The probationary order can just have the medical record keeping and the prohibition on recommending marijuana. It can be 3 years, 5 years. I'm not making a recommendation regarding that, but it needs to comply with the law. And 2227 is violated here, plain and simple. With that, I will submit it.
Right, thank you very much. Okay, did any members of the panel have any questions for our respondents' counsel, or our, yes?
Mr. Garcia, is Dr. Shaham willing to answer any questions?
Yes, he is. Yes, he is.
Okay, Dr. Shaham, so you,
Then maybe I'll put him under oath before we do
Yes,
that?
please, go.
Okay,
Yes.
all right. Dr. Shaham, would you stand and raise your hand? Raise your right hand. Do you solemnly swear or affirm under penalty of perjury that your testimony in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Okay, go ahead.
so Dr. Shaham, you don't need to answer the first question, but I do want to make sure that you can answer the second one. Now, my first one is, you had a busy OBGYN practice. Why did you get into marijuana recommendations? And second one is, are you willing to stay away from the rest of your practice career into marijuana recommendations or anything which we are not trained in our specialties? I'm a surgeon, you're an OBGYN, so we're trained certain way. We don't do liposuction, usually don't do marijuana recommendations, so that those are the two questions.
What were the two questions? To answer the second question is yes. I'd be willing to stay away from it. How did I get into it? I was in the process of retirement, actually 3 OBGYN doctors, and we set up first we covered another clinic that was giving marijuana recommendations. And then we started doing it ourselves. We gave marijuana recommendations, thousands of patients with a lot of experience. The physical exams were basically brief exams, which take a few minutes. Some of them took over 30 minutes, depending on what the situation was. If they had cancer or other issues, we spent more time. If they just complained of a sleep problem or muscle aches, and it improved their lives to get marijuana recommendations. It was perfectly okay to give them the marijuana recommendation, which was fine. Like the two people here, investigators, had muscles post-exercise, and they had plantar fasciitis, which even the expert witness says it's horrible. Their expert witness said it's horrible pain, he couldn't walk, and so on. So we spent a little bit more time. We also gave, or at least I gave.
I think you've gone beyond the scope of the question.
Yeah. Thank you. Did you have any other questions? Anyone else have any questions on the panel? No. All right, thank you.
I do have a
Yes.
question. Doctor, did you have a different way of examining patients in your medical marijuana practice than you did with your OBGYN practice? And did you have a different way of keeping records?
Yes and no. I mean, I don't do pelvic exam on the patients. I listen to the lungs, hearts, and check the belly for hepatomegaly, basically, or tenderness, for which I don't do it lying down. I don't need to do it lying down. Other than that, I don't think there is much difference as far as the medical records. I set up my own form, which check marks basically cover most of the findings, and that's it. The big issue for a long time there was a thyroid exam, whether it requires palpation or not, when they had no symptoms and there's no apparent swelling. I didn't go ahead and touch the thyroid. They made a big deal of it. and their expert.
So again, Dr. Shaham, I just want to make sure we don't exceed the scope of the evidence, so maybe just really pay attention to the question and limit your answer to
Okay,
that.
it was in the evidence. Basically, no. A physical exam here, and here it's basically the same except for the gender and so on, but basically they get the same exam.
Was your OBGYN practice walk-in? Well, was the medical marijuana practice a walk-in practice?
Yes, it's
Okay,
actually
and
most.
was the OBGYN practice a walk-in practice?
Yes, it's a walk-in practice except for recurrent patients. I've had patients for 20-some years. They came in initially by walk-in, no advertising, almost no advertising here, basically no advertising. So I don't bring them in. I don't do 50 exams. It's about 20 exams maybe, and plenty of time to be more particular with a particular complaint. I treated it like in medical, where you have brief exams and comprehensive exams. Their expert witness said, oh, you have to put them on a table, you have to palpate this, and so on. And I treated it as what medical, the state medicals, for a brief exam, for a brief complaint.
Okay, thank you.
All right, any further questions from any members of the panel? Okay, then we will close the hearing at this time. Thank you very much. We're off the record.
Panel B? Are councils ready, or want a couple of minutes?
I'm ready.
I'd like to introduce Judge Jill Schlichtman.
Good morning, everyone. Let's go on the record before the Medical Board of California on the matter of the statement of issues against Hu Hua Victoria Van. This is Office of Administrative Hearings, case number 2015-07-1026, and board case number 800-2015-011627. Today's date is July 28, 2016. We are in South San Francisco, California for the hearing in this matter. My name is Jill Schlichtman. I'm the administrative law judge that's been assigned to preside over this matter by the Office of Administrative Hearings. I'll take the appearances of counsel for the record, please, starting with Complainants' Counsel.
Greg Chambers with the Attorney General's Office representing the Medical Board of California.
Thank you.
My name is Michael Firestone, and I'm representing Dr. Van, who's here on my left.
Thank you. All right, I think you are both aware, but I'll just reinforce that today's hearing is for the purpose of argument only, not the submission of new evidence. And Mr. Firestone, were you planning to have your client testify at all, or just your own argument?
She's here also to make a statement and
Okay.
answer any questions.
All right, so that will be within your first 15-minute allotment then, or?
That would be fine, or we could save it for the end.
Okay. All right. Well, I'll, as you know, you each get 15 minutes for your opening argument. And would you like me to let you know when you have 2 minutes left, or?
Sure, that'd be great.
Okay. All right. Then, Mr. Firestone, you can go ahead and give us your closing argument. Thank you.
Good morning, Your Honor, and good morning to the honorable members of the Medical Board. Thank you for giving Dr. Van this opportunity to speak with you about the board's non-adoption of the proposed decision. Initially, I will discuss why we're here and what must be decided today. I'll review a little bit about the background information and try to put into context, historically, the out-of-state conviction that Dr. Van had. I'll also try to argue why adopting the proposed decision is warranted in this case, based on the totality of the evidence that supports the fact that the existing terms adequately protect the public as they are written in the proposed decision. To that end, I will discuss how Dr. Van has been able to keep up with her medical knowledge, even though she's been out of practice for quite a while. And I'll describe her future plans and provide of her providing much-needed medical services to an underserved patient population. And then finally, Dr. Van will answer any of your questions and make a short statement. As you know, this case came before the Medical Board as a statement of issues based on Dr. Van's appeal of her denial of her medical license, based on an out-of-state conviction. There was a one-day hearing in January of this year in Los Angeles, and the ALJ drafted a proposed decision dated March 3rd, 2016, which granted Dr. Van her medical license with specific probationary terms and conditions for a period of 5 years. Beyond the standard terms and conditions, the proposed decision's order included the following requirements. She was to have a practice monitor. She was restricted from supervising physician assistants. She had to have additional education consisting of 40 hours per year of probation. She was required to have a prescribing practices course, medical record keeping course, and ethics and professionalism course. Dr. Van was then notified that the Medical Board had decided to non-adopt the proposed decision, and she was invited to present argument today related to the level of discipline imposed. Dr. Van and I are very hopeful that after today's presentation, the members of the board will have complete confidence that adopting the ALJ's decision as written is the correct and prudent course of action. We're hopeful that the board members will agree that the ALJ correctly found that Dr. Van has established her rehabilitation such that her relicensure would pose no danger to the public health, safety, and welfare, and that the totality of the evidence established that while a practice monitor would be appropriate condition of probation, the additional condition of completion of the PACE program is not warranted. I'd like to put some historical context into what occurred that got Dr. Van into trouble. You know, although California case law supports the notion that we're supposed to mostly focus into the Dr. Van's rehabilitation and character since her license in Mississippi was disciplined and surrendered, as well as the criminal conviction, and not on the events that happened before that time. But I think it's important for the board members to put into context the underlying conduct that occurred out of state, which will hopefully help explain why it is unlikely to reoccur in the future. The underlying conduct that led to Dr. Van's arrest involved a single misdemeanor offense for the distribution of a Schedule V controlled substance outside of the scope of professional practice. The charged conduct related to a single patient that Dr. Van treated in Biloxi, Mississippi, in the Gulf Coast in May of 2008. Backing up a little bit from the criminal conviction, it's important to understand what was going on during that period of time. Now, Dr. Van had a prior California license for many years. She was trained here, and she lived here for many years. But she moved to Biloxi, Mississippi in 2002 to join her husband's existing medical practice. Dr. Thomas True, at that time, was the only Vietnamese-speaking physician in the area. I personally didn't realize this fact until I was working with Dr. Van on this case, but apparently the Gulf Coast region is home to many Vietnamese Americans who immigrated there to work in the Gulf's shrimping industry and the seafood processing plants there. So it was not uncommon for patients to drive for many miles to go see her, long distances, and Dr. True. In 2004, they welcomed their first child, Jaden. In the summer of 2005, she learned that she was pregnant with her second child. And in August 2005 is when Hurricane Katrina hit that area. It was during that time that Dr. True's medical practice was devastated by Hurricane Katrina. And the damage to the Biloxi area was overwhelming. Overall, over 1,000 people died, and during the subsequent floods and the storm, making it one of the deadliest hurricanes in the United States since 1928. Total damage was estimated at $108 billion. Dr. True's medical office building was completely destroyed. Patient files were ruined, and like so many families in the region, they were displaced from their home. Despite pressure from their families to move away and move back to California, they chose to stay and try to rebuild. So they did their best to rebuild their medical practice and recognized an extreme need for medical care during that time. It's hard to imagine how much of the destruction of Hurricane Katrina changed the landscape of the Gulf Coast region. Not only the buildings and infrastructure, but the people were impacted severely, not only financially, but mentally and physically as well. The devastation led to many social problems and unique health problems. People were displaced, many were unemployed, and many had lost everything, including family members. This led to increased cases of post-traumatic stress disorder, anxiety, and depression, all at a time when the county mental health services were really hard to get. So this put a huge stress on primary care physicians to treat patients with mental health issues. There were also some unique physical disorders that popped up after Hurricane Katrina, such as respiratory disorders and skin disorders. These were a result of the mold and mildew and the debris that Hurricane Katrina caused. There was an increased number of respiratory complaints, or post-Katrina cough was what they called it. It was also caused by the formaldehyde that was in these trailers, the FEMA trailers that were placed for people that were displaced from their homes. So since so many physicians left the area and there was such an increased demand in medical care that was needed, this caused a huge influx of patients to their practice. The reason that I mention this is that it's a combination of all of these factors that gradually led to the increase in the number of patients coming to Dr. Van's husband's clinic. During this time, Dr. Van had her second child in February of 2006. and she drastically cut back her medical care that she offered at the clinic. She was only working there 1 or 2 afternoons a week, and as a result of the increased patient volume, Dr. True simply took on too many patients. So in the afternoons that Dr. Van did actually go to work at the clinic, she tried her best to help alleviate some of the patients that were building up in the waiting rooms, and oftentimes would treat patients that weren't typically her patients, but were patients that were her husband's patients, just to help so they weren't waiting so long. So that was the case for the patient that she ended up getting charged for the promethazine with codeine. She had seen this patient who was her husband's prior patient and essentially refilled the patient's prescription. She didn't do a very thorough physical exam and didn't recognize that the patient's condition was lingering, and maybe she should have sent the patient to have some additional diagnostic testing. She recognizes these and has admitted her mistakes, but these are the things that the board can be confident that would never reoccur, since Dr. Van has completed the board-approved remedial education courses in record-keeping, prescribing practices, and ethics. Now, keep in mind, at this time, what we take for granted here in California, the Cures database system, was not available in Mississippi at that time. In addition, a lot of the patient's records that were simply just destroyed in the storm, so it made it very difficult for even the best of doctors to try to track down whether this patient had had other legitimate health conditions. So it wasn't until later that they realized, that Dr. Van realized, that many of the patients were exaggerating their health claims and were using that as an excuse to try to obtain controlled substances. I'm trying to make a long story as short as possible, and will do my best not to leave out any of the pertinent facts. But if I miss anything, if the board has any questions, I invite you to ask Dr. Van, and we can help clarify anything that's still lingering. So what ultimately happened is the authorities in Mississippi became concerned about the clinic's high volume of patients that were going there, the high volume of prescriptions, and attributing to lingering respiratory conditions and mental health needs. So they ultimately executed a search warrant and in 2008 and searched the house and searched the clinic. At that time, both Dr. Tran and Dr. True were asked to surrender their DEA privileges and medical licenses issued by the Mississippi State Medical Board. And in an effort to fully cooperate with the authorities, they agreed to surrender their DEA privileges and medical licenses that day. They weren't represented by an attorney at that time. Now, following their arrest and indictment, they both remained in custody away from their children for nearly 3 months until the judge finally posted bail, or granted bail. It was revealed after the government reviewed all of the medical records that they had taken that it was clear that Dr. Van had seen far fewer patients than Dr. True. So ultimately, the government was willing to settle with Dr. Van to plead guilty for just one misdemeanor count of distribution of a Schedule V controlled substance outside of the scope of professional practice. And it was Dr. Van's understanding that the government prosecutor was going to recommend probation to the judge. On the day of sentencing, however, the judge ignored the prosecution's recommendation for probation and ordered Dr. Van into immediate custody, and she was to serve 1 year term of confinement. She was not allowed to see her children or her family before being taken away, which was somewhat not expected. I think it would be hard for anyone to argue that Dr. Van hasn't paid a substantial debt to society for her conduct. Her sentence for a misdemeanor conviction took her away from her 2 young boys. She ultimately served 6 months in custody and was then able to transfer her sentence to a supervised living facility in Southern California. And she was released in October 2010.
And
Now
you have 2 minutes left.
It is the reasons why the board should adopt the proposed decision is that Dr. Van understands that it was her burden to prove that she was worthy of a medical license. She had a very high hill to climb, and she has done so, and has set an example for others. In fact, the evidence is overwhelming to prove that she was worthy of a medical license and has been fully rehabilitated. The ALJ who presided over the one-day hearing, who heard witness testimony, observed witness credibility, and considered all the evidence and arguments, was convinced that Dr. Van had met her burden of proving that she is rehabilitated and she was no longer a danger to the public. The ALJ drafted a thoughtful proposed decision and did a superb job of summarizing the relevant evidence. Now, I think the board members would agree that the most compelling and hopefully reassuring evidence of Dr. Van's professional competence is her current employer. Dr. No's steadfast willingness to hire Dr. Van as a physician in his primary care practice, if she were granted a license, is a good testament to her qualifications. He's basically had a 5.5-year job interview for her. He's seen her competence, and he's actually already testified credibly, that the judge found credibly, that she, if she was given her license, would be able to treat his own family members, not only his patients, but also his own family members, including his children. Dr. Van speaks excellent English as well as Vietnamese, and she would be serving an underserved patient population. She's fortunate to have a job waiting for her from a boss who values her work and commitment to medicine. Assuming that Dr. Van is granted a second chance and obtains a medical license, Dr. Van anticipates working for Dr. No in Southern California and treating the Vietnamese population in Orange County. She also intends to pursue her pediatric medicine reboard certification and then her internal board recertification. She had been previously double board certified.
All right, and your time is up. Thank you, Mr. Firestone. Mr. Chambers?
Thank you. At the hearing, and again today, what we heard was an attempt to minimize the actions of respondent in Mississippi. The judge scuppered the deal offered by the U.S. attorney because, as he said, quote, it was a criminal enterprise, close quote. This was not about a single patient. Not only did Dr. Van serve time, she was sentenced to 1 year plus 1 year probation. Her husband served time, and the pharmacist who was involved with them also served time. This is a group that was making money hand over fist, as was provided in the evidence, to the underserved in that community in the years subsequent to Hurricane Katrina. Dr. Van has not practiced medicine in the state of California for 14 years. Dr. Van has not practiced medicine at all for 8 years. It is the position of the medical board that, based upon the actions of Mississippi and the events that occurred during and after Hurricane Katrina, that the respondent has still not rehabilitated herself while she's come back to the state of California. If, however, the board, this panel, believes that she has rehabilitated herself, we note the ALJ's opinion fails to require a PACE assignment. With 8 years and 14 years non-practice, there is no way the public safety can be certified by the medical board without a proper assessment of the skills that are currently possessed by the respondent. And with that, we would submit.
Okay, thank you. Mr. Firestone, would you like to, you have 5 additional minutes for your closing argument.
Okay, thank you.
Go ahead.
To the point of that counsel from the complainant has made regarding Dr. Van and her husband making money hand over fist, I think that's a misleading statement. The values that were quoted in complainant's written argument of making $600,000 1 year and $800,000 the next, I think is also misleading, because that was a gross amount. That was what the practice was making. That wasn't profit. That wasn't what they were taking home as profit. So I think that also needs to be taken into context. They had to pay their rent. They had to pay their employees. It wasn't profit. She's practiced in the setting has been very lucky to practice in a setting as an office manager of a very busy primary care clinic in Orange County for the last 5.5 years, where she's been submerged in medical knowledge and basically done everything involving medical care except actually providing the medical care. The treatments she's kept up with because she sees what the patients are being diagnosed with. She's familiar with the EMR system, the billing codes, the diagnoses. She's actually attended several conferences. She remains in her practice. Her boss, Dr. No, puts on a weekly radio show regarding medical issues, and she's the one that researches each week's medical content and topic. All these are all the new, hot topics of today. So she's familiar with today's cutting-edge treatments and medical issues. She's already taken an additional annual conference in April of this year after the hearing took place, and that was discussed in the respondent's written argument. The fact that she has the total support of Dr. No, her current employer, who's in the best position to assess her judgment and her medical competence, I think is the best evidence that the board can use that she is ready and capable. She's also demonstrated clear examples of the lessons that she's learned through this entire process and has tried to use it as an entire learning experience. She's also completed already the medical record keeping courses, the prescribing praxis courses, and the ethics courses that the board uses to help remediate physicians who are undergoing discipline. She intends to treat an underserved patient community, and she has the support of her family and of her community. Disciplinary action is not intended to punish, but rather should be meted out with the goal of rehabilitation of the licensee.
And Mr. Firestone, let me just let you know that if you wanted to present testimony from your client, you need to do that within your allotted time. You can certainly offer her to answer questions of the board, but if you wanted her to present testimony,
Okay.
you have 2 minutes left.
Okay, then she would like to present now.
Okay. All right. Can you first stand and raise your right hand to be sworn? Do you solemnly swear or affirm under penalty of perjury that your testimony in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Thank you. Okay. Go ahead.
First of all, I'd just like to thank you, members of the board, just for giving me this opportunity to be here and to review my request. I'm here today because it's a result of my actions and the mistakes and my deficiency as a physician, what I did in the state of Mississippi. And because of it, I've jeopardized the trust of the medical profession, and I'd also failed to my duties to safeguard and protect patients who were entrusted under my care. I accept full responsibility for my action and for my inaction as well, and also for my poor judgment, as I did not do enough to stop or prevent potential for misuse or abuse in these cases. I understand the concerns of the medical board because of the serious mistake and the nature that I was involved in, and at a great price, I had learned many valuable lessons, especially to be stronger in my character as a person, to say no, to speak up and not give in to the demands of patients or others. I learned that I needed to be responsible for the evaluation of each and every patient I saw, even though I may be cross-covering for them. And then I learned that I need to utilize other resources available by referring them for testing or referrals to specialists. And although I may have respect for the physician I work with, but I need to question them and also to see area of concern in the management and document and take corrective action. During my confinement, I immersed myself in self-evaluation and learning, although they could not rectify what happened. but I want it to be a
And
better and a
I'm sorry,
responsible
but-
person.
We're out of time, but thank you. The board members may have some questions for you afterwards, all right?
Sure.
Okay, Mr. Chambers, did you have any additional comments?
Just finally, with regard to the education that was presented just moments ago, we cannot, the community at large, and the medical board, which has a duty for the public safety, cannot accept a self-assessment with regard to the knowledge and skills of the respondent. And until there is a full evaluations of the skills and knowledge of the respondent, it would be inappropriate to offer probationary license unless and until that PACE requirement is added and fulfilled as a condition precedent. Thank you.
All right, thank you very much. Okay, at this time, do the members of the panel have a question? Yes?
Thank you, Judge. Dr. Van, I saw that your one count you accepted in Mississippi was a Schedule 5 drug, which is an antihistamine. But did you ever get calls from either the hospital emergency room or the coroner's office that your patients overdosed anytime during that practice? I don't have that information.
No, I did not have any patient whom I saw or prescribed that overdose that I was involved with in the care, no. This patient was a patient who was non-compliant and was a smoker, and I saw the patient as a coverage and refilled the medication. I was not made aware of what some of these patients were doing until later on, when I was made aware, because it was a cough prescription that I drastically decreased the prescription and changed my prescribing habit.
All right, do any other panel members have another question? Any other question? Yes?
I do. I would just like to hear more about, from respondents' view, more about the PACE, the requirement to take on the PACE courses, and what's your view, doctor, on that, and would that not be helpful for you?
Yeah. I would be willing to do what the board deem necessary to say that I'm safe and to practice. But I realize I have not been in practice for a long time, so that's why I started attending live CME courses. And since 2004 until now, I have accumulated 127 hours of attendance to the CME courses. And those including the prescribing courses, medical ethics, and medical record keeping. The office where I'm working allowed me the opportunity to work with patients, providers, other hospital healthcare services such as hospital pharmacies and insurance plans, where I get a lot of calls regarding medication clarification, lab orders, or results that were viewed by physicians, and even to submit, to review notes for audits, for quality measure reporting, or preventative screening measures. So I'm immersed daily in the care, in reviewing the records, the doctor notes, reviewing labs and prescription, so that helped me to be able to be in the medical environment and to keep up. And Dr. Ngo always, he's an ongoing learner, challenges me with little projects and looking up things like what should we do in this case, in this patient with an abnormal lab or an abnormal pap smear or has positive HPV. So what do we do in this, Victoria? And he would have me look things up or find the protocol for this. And so those are the things I do at the office with him for the past 5.5 years. In regard to the PACE evaluation, I learned that it's a 7 days program, 2-phase, and I was quoted the cost would be about $16,000 to $19,000 for the program. So for me, financially, it's cost prohibitive. And I just would like the board to respectfully look for other alternatives. Should I do more CME courses or classes as alternative to the PACE requirement?
Okay, any other questions? I don't hear any, so thank you, everyone. We're going to close the hearing at this time. We're off the record.